My name's Damian Munsinger, and I'm an employment lawyer in Oregon and Washington. You're watching 120 Seconds, an occasional web series from Klein Munsinger, where we answer an employment law question all lawyers need to know the answer to. Today we're talking about non-competition agreements in the state of Oregon. The House and Senate just passed Senate Bill 169, and it's on its way to the governor's desk if it hasn't arrived there already. Senate Bill 169 makes several key changes to Oregon's unique non-competition agreement statute, which provides the requirements that must be met in order for a non-competition agreement to be enforceable in the state. The first big change is previously non-competition agreements that didn't meet the statutory requirements were voidable, and now they are void and unenforceable. That small change is really important because courts had interpreted that voidable language to mean that the employee had an affirmative duty to notify their former employer that the non-competition agreement they had with them was inconsistent with Oregon law. Now that is no longer the case, and they will just be void and unenforceable regardless of whether the employee says so or not. The second big change is previously there was a minimum income that you had to have in order to be subject to a non-competition agreement, and it was vaguely defined as, I think, an average income for the family of four according to the Census Bureau, something like that. Anyway, it was a number that was nearly impossible to track down, and they've now put some hard digits into the statute. So if you are an employee who makes less than $100,533 per year, you cannot be subject to a non-competition agreement in the state of Oregon. That number is going to be adjusted annually for inflation, so we'll see that minimum salary requirement grow over time. Another big change is the maximum amount of time that you can be subject to a non-competition agreement. The previous statute maximized the amount of time at 18 months, and we're cutting 6 months off that. So now a year is the maximum amount of time that you can be subject to a non-competition agreement in the state of Oregon. And you should note that these changes are going to go into effect only for agreements entered into after the effective date of this. It has not yet become a law, but it will soon. And so agreements to not compete that are in place now are not going to be affected by this new law, but new non-competition agreements will be. It's quite a bit different from Washington, which recently passed a non-competition statute that does look back and affect previous agreements, and way different from California, where non-competition agreements are pretty much entirely prohibited. That's it. Thank you so much for watching. Please email 120 seconds at kleinmunsinger.com if you'd like us to answer a question in the future, and we'll talk to you soon.